Today we are going to look at some landlord-tenant board scheduling horror stories. Waiting in the queue. A couple whose only source of income was Ontario Disability Support Program benefits approached a legal clinic in late 2018, concerned about the deplorable state of their rental unit. The clinic was in the process of attempting to obtain compensation from the landlord when in April 2019, the building was shut down due to electrical safety concerns. The tenants left belongings behind that were later ruined by water damage. Their applications to the board were filed on March 31, 2020, but they were unable to obtain an expedited hearing, and the matter was not scheduled for a hearing until December 2021, leaving them waiting for almost 2 years for a hearing date. A tenant filed an application for tenant rights and maintenance in December 2020 because her landlord had been harassing her and her apartment had black mold, inadequate heat, leaks in the windows and sink, and a malfunctioning stove. She claimed her poor living conditions were causing her health problems, and she had been waiting more than a year for a hearing. With no solution in sight, she was forced to leave her home of 8 years in May 2021. A hearing was eventually scheduled in January 2022. But it was adjourned because there were too many cases to be heard that day. It was adjourned again at a hearing in March because the presiding member was due to leave the board and felt that another member should be assigned to hear the matter, given the volume of evidence involved. The hearing was eventually rescheduled for April 2022. A woman complained that her landlord, his son, and others were harassing her, including shutting off her heat, looking in her windows, and drilling holes in her ceiling. She said police had been contacted about the landlord's harassment several times and she had filed applications with the board for a rebate and tenant rights in September 2020. Her matter was not scheduled for a hearing until November 2021, and then it was adjourned. Her request to have it expedited was declined, and it was not scheduled again until February 2022. 1.5 years of waiting. One man was forced to live in a homeless shelter. He had purchased a home that had a tenant in residence in 2018. The tenant had never paid him any rent. While he waited for the board to consider his application to terminate the tenancy, he was living in a trailer without utilities and visiting shelters to get out of the cold. A 74-year-old landlord, a pensioner, had applied in December 2019 to end a woman's tenancy because of serious safety concerns. The tenant had assaulted him, once threatening him with a knife, and on other occasions throwing stool and urine at him and another resident. She had also intentionally flooded the rental unit with excrement and toilet water, altered the electrical panel, and added an extra stove without authorization. The tenant was also allegedly operating a grow-op and selling drugs from the unit. Despite the egregious situation, the board did not hear the case for a full year, and the order requiring the tenant to vacate was not issued until January 2021. A 2-year wait. A man who rented out his basement applied in December 2019 to end the tenancy for personal use, so he could move his son, who is on the autism spectrum, into the unit and care for him. Scheduling of the hearing was initially delayed because the board could not locate an interpreter for the French-speaking tenant. Then it was postponed indefinitely due to the pandemic. The tenants subsequently filed an application in May 2020. A lack of French language services contributed to the delay in scheduling, and when the applications eventually came up for hearing in November 2020, they were adjourned. The hearing finally took place in February 2021, more than 2 years after the landlord had first applied to the board. There was the man whose tenant had made only 2 payments since August 2019. On December 23, 2019, he applied to terminate the tenancy for non-payment. He obtained an eviction order on February 13, 2020, but the tenant requested a review, and the board granted this request. A review hearing scheduled for May 2020 was cancelled because of the pandemic. When hearings relating to evictions commenced again in August 2020, the file went missing and the matter was not scheduled for a hearing until April 12, 2021. More than 2 years after the landlord originally filed the application, the tenant's rental arrears had surpassed $36,000. An eviction order was finally issued in March 2022. In October 2022, a landlord reported that both tenants in a building he owned had stopped paying rent earlier in the year. His applications with the board to terminate the tenancies had still not been heard. One tenant eventually moved out but left the unit severely damaged and uninhabitable. As a result of the financial hardship the situation had caused him, the landlord was living in his car. Fatal errors. After months and sometimes years of waiting, individuals are often told by a member at a hearing that their applications have fatal errors, forcing them to start the process over again. In one particularly compelling case, a woman who lived in her basement and leased the upper half of her home while she was dying of stage 4 cancer. She had filed an application in December 2021 to end the tenancy of the unit for personal use, so she could pass away in a peaceful environment. Her request for an expedited hearing was approved, and the matter was scheduled for hearing on February 24, 2022. However, it was adjourned to March 9 because there were too many cases to be heard that day. On March 9, the woman waited for her virtual hearing to start, only to learn that it had not been properly scheduled. When the matter was finally heard on March 18, the application was dismissed because she had failed to include the unit number on her application. By then, the tenants had not paid rent for several months and were tormenting her during her final days, recording videos of visitors to the home, releasing their dogs to harass nurses and medical suppliers, blasting music all day, and shouting obscenities. Police were also called to the home repeatedly to address death threats against the woman and sexual harassment of her daughter. The woman was forced to start the application process all over again. She passed away on May 1, 2022, with the matter still before the board and unresolved. Limited remedies. The board is limited in what it can do to help members finish outstanding orders since as independent decision-makers they are entitled to complete the decision-making process. The board's inability to address significant delays on the part of individual adjudicators can have extreme impacts on participants awaiting resolution. For example, a landlord filed an application on June 5, 2020, for eviction for non-payment of rent. The original hearing was scheduled for December 8, 2020, but was adjourned by the member. The member was scheduled to hear it again on February 17, 2021, but no one appeared to preside over the hearing that day. The tenant then filed an application in February 2021 regarding an illegal lockout, and the board issued an interim order on March 31, 2021. Preventing the landlord from renting out the unit and ordering that the tenant be allowed back into the rental unit. On April 20, 2021, the member heard both applications. However, a year later, no orders had been issued. In May 2022, the landlord asked the board to grant him an expedited hearing before another adjudicator. This request was denied since a hearing had already been held back in April 2021. The order was still outstanding in December 2021, at which point the tenant owed arrears of over $19,000. Another interim order on the tenant's application was issued on October 11, 2022, but the prolonged delay and presiding member's imminent departure resulted in both the landlord's and the tenant's applications being scheduled for a new hearing before another adjudicator on November 9, 2022. A landlord filed an application on January 7, 2020, to end a tenancy because she required the rental unit for personal use. The original hearing was scheduled for May 8, 2020, but was canceled due to the pandemic. The matter was heard on December 18, 2020, and an order was issued on December 22. Requested a review of the order, which was heard by the member on April 12, 2021. 17 months later, the order was still outstanding, and the landlord and her family had to live in substandard conditions while waiting for a decision with no end in sight. On November 24, 2022, an order was finally issued on the review, dismissing the December 2020 order, and requiring a new hearing on the original application for eviction to be scheduled, almost 3 years after the landlord's application was filed. A landlord filed an application to end a tenancy because the tenant had failed to meet the conditions of a previous order. The application was filed on February 24, 2021, and an order was granted on March 19, 2021. The tenant then filed a motion to set aside the order, and a hearing was scheduled for April 22, 2021. The member heard the motion, but over a year later had not issued an order. While the tenant eventually left the property, the landlord was stuck with $11,000 in rent arrears that she has not been able to pursue. It wasn't until December 2, 2022, that the order was finally issued, denying the tenant's motion and lifting the stay of the eviction. A landlord filed 2 applications with the board to evict a tenant. The first was heard before the member in February 2021. The hearing wasn't completed on that day, and the member said she would hear both applications later. However, the member did not record this direction with the board until October 2021. In the meantime, the second application was scheduled for a separate hearing before another member in June 2021 but adjourned because there was insufficient time for it to be heard. The matters were finally both heard together on June 13, 2022. In October 2022, the landlord was still waiting for the matters to be resolved. He was owed arrears of $44,000, a sum that continues to grow as he waits for the orders to be issued. He said this was his first experience with renting out a property, and he has incurred financial hardship because of the situation. The order was not produced until January 4, 2023.